Commercial lease agreement for use in the province of British Columbia. So right over here, this is the parties. Put the landlords in these two lines. Going down, and tenants, put them on these lines. Then put in the property address. Okay. Number 1, rental amount. Commencing, so put the date here. And to make it current, we'll put 2017. So whatever the date is, 2017, tenant agrees to pay landlord the sum of $1,500 per month in advance on the first day of each calendar month. Said rental payment shall be delivered by tenant to landlord or their designated, I guess his or her designated agent. All right. Rent must be actually received by landlord or designated agent in order to be considered in compliance with the terms of this agreement. Number 2, term. The premises are leased on the following lease term. Please check one item only. So blank line here for the date for 2017 until whatever date, say for example 2019, whatever you want. 3, security deposits. Tenant shall deposit with landlord the sum of, and here you put the sum of money, as a security deposit to secure tenant's faithful performance of the terms of this lease. After all the tenants have vacated, leaving the premises vacant, the landlord may use the security deposit for the cleaning of the premises. Any unusual wear and tear to the premises or common areas, and any rent or other amounts owed pursuant to the lease agreement or pursuant to Real Estate Act of British Columbia. Tenant may not use said deposit for rent owed during the term of the lease. Within 21 days of the tenant vacating the premises, landlord shall furnish tenant a written statement indicating any amounts deducted from the security deposit and returning the balance to the tenant. If tenant fails to furnish a forwarding address to landlord, then landlord shall send said statement and any security deposit refund to the leased premises. 4, initial payment. Tenant shall pay the first month rent of, put the dollar amount in here, upon signing of this contract and the security deposit in the amount of, and then you put the blank here, before possession of the premises. Said payment shall be made in the form of cash or cashier's check, should be Canadianized, and is all due prior to occupancy. 5, use of property by tenant. The leased property may be occupied and used by tenant exclusively to be known as a, and here's a blank line where you put the definition in there. The tenant shall not use the property for any other use. So that blank line was for the use of the property. 6, subletting or assigning. The tenant reserves the right to sublet the premises with written consent by the landlord and at no additional cost, and the tenant to provide additional insurance during such time and provide a copy of the insurance policy to the landlord. Tenant agrees not to assign or sublet the premises or any part thereof without first obtaining written permission from landlord. 7, utilities. Tenant shall pay for all utilities and or services supplied to the premises with the following exception: taxes and city utilities. 9, parking. Only vehicles that are operational and currently registered in British Columbia, the province of British Columbia, right, may park at this house. Any vehicle that is leaking any substance must not be parked anywhere on the premises. 9. Condition of premises. Tenant acknowledges that the premises have been inspected. Tenant acknowledges that said premises have been cleaned and all items, fixtures, appliances, and appurtenances are in complete working order. Tenant promises to keep the premises in a neat and sanitary condition and to immediately reimburse landlord for any sums necessary to repair any item, fixture, or appurtenance that needed service due to tenants or tenants' invitee misuse or negligence. Tenant shall be responsible for the cleaning or repair to any plumbing fixture where a stoppage has occurred. Tenant shall also be responsible for repair or replacement of the garbage disposal where the cause has been a result of bones, grease, pits, or any other item which normally causes blockage of the mechanism. The tenant must leave the premises clean and in the condition it was received in when vacating the premises. 10. Alterations. Tenant shall not make any alterations to the premises, including but not limited to installing aerials, lighting fixtures, or other items without first obtaining written permission from landlord. Tenant shall not change or install locks, paint, or wallpaper said premises without landlord's or landlord's agent prior written consent. Tenant shall place placards, Tenant shall place placards, signs, or other exhibits in a window or any other place where they can be viewed by others. Did I get that right? Oh yeah, so you need the written consent to place placards, signs, or other exhibits in a window or any other place where they can be viewed by others. Tenant reserves the right to paint the premises for the duration of the lease and will not repaint back to original color upon vacating. 11. Late charge bad checks. A late charge of 6% of the current rental amount shall be incurred if rent is not paid when due. If rent is not paid when due and landlord issues a notice to pay rent or quit, tenant must tender cash or cashier's check only. All right? If tenant tenders a check which is dishonored by a banking institution, then tenant shall only tender cash or cashier's check for all future payments. This shall continue until such time as written consent is obtained from landlord. In addition, tenant shall be liable in the sum of $30 for each check that is returned to landlord because check has been dishonored. All right. 12. Noise and disruptive activities. Tenant and his or her guests and invitees shall not disturb, annoy, endanger, or inconvenience other tenants of the building, neighbors, the landlord, or his agents, or workmen or women, nor violate any law, nor commit or permit waste or nuisance in or about the premises. Further, tenants shall not do or keep anything in or about the premises that will obstruct the public spaces available to other tenants, to other residences. Lounging or unnecessary loitering on the front steps, public balconies, or common hallways that interferes with the convenience of other residents is prohibited. 13. Landlord's right of entry. Landlord may enter and inspect the premises during normal business hours and upon reasonable advance notice of at least 24 hours to tenant. Landlord is permitted to make alterations, repairs, and maintenance that, in landlord's judgment, is necessary to perform. In addition, landlord has all right to enter pursuant to the Residential Tenancy Act. If and only if emergency work has to be performed, according to the Residential Tenancy Act, requires that tenant temporarily vacate the unit, then tenant shall vacate for this temporary period upon being served a 7 days notice by landlord. Tenant agrees that in such event, the tenant will be solely compensated by a corresponding reduction in rent for those many days that tenant was temporarily displaced. If the work to be performed requires the cooperation of tenant to perform certain tasks, then those tasks shall be performed upon serving 24 hours written notice by landlord. Example, removing food items from cabinets so that the unit may be sprayed for pests. 14. Repairs by landlord. Where a repair is the responsibility of the landlord, tenant must notify landlord with a written notice stating what item needs servicing or repair. Tenant must give landlord a reasonable opportunity to service or repair said item. Tenant acknowledges that rent will not be withheld unless a written notice has been served on landlord, giving landlord a reasonable time to fix said item within the meaning of the Real Estate Services Act. Under no circumstances may tenant withhold rent unless said item constitutes a substantial breach of the warranty of habitability as stated in the Real Estate Act. 15. Pets, no dog, cat, bird, fish, or other domestic pet or animal of any kind may be kept on or about the premises without landlord's written consent. 16. Bylaws. Tenant must comply to the strata bylaws of the premises. 17. Insurance. Tenant may maintain a personal property insurance policy to cover any losses sustained to tenant's personal property or vehicle. It is acknowledged that landlord does not maintain this insurance to cover personal property damage or loss caused by fire, theft, rain, water overflow, leakage, acts of God, or any other causes. It is acknowledged that landlord is not liable for these occurrences. It is acknowledged that tenant's insurance policy shall solely indemnify tenant for any losses sustained. Tenant's failure to maintain said policy shall be a complete waiver of tenant's right to seek damages against landlord for the above stated losses. The parties acknowledge that the premises are not to be considered in security building which would hold landlord to a higher degree of care. The tenant must maintain a third-party liability insurance policy for the minimum of $1 million. A copy of such policy must be provided to the landlord or landlord's agent. 18. Termination of lease rental agreement. If this lease is based on a fixed term pursuant to paragraph 2, then at the expiration of said fixed term, this lease shall be renewed as a monthly tenancy on the same terms until the tenant gives notice to end a tenancy. At any time after the fixed term has expired, the landlord agrees to give 3 months vacated notice to the tenant to vacate the premises. The landlord and tenant may mutually agree in writing to end this tenancy agreement at any time. 19. Possession. If premises cannot be delivered to tenant on the agreed date due to loss, total, or partial destruction of the premises, or failure of previous tenant to vacate, either party may terminate this agreement upon written notice to the other party at their last known address. It is acknowledged that either party shall have no liability to each other, except that all sums paid to landlord will be immediately refunded to tenant. 20. Abandonment. It shall be deemed a reasonable belief by the landlord that an abandonment of the premises has occurred where the, within the meaning of the Residential Tenancy Act, where rent has been unpaid for 14 consecutive days and the tenant has been absent from premises for 14 consecutive days. In that event, landlord may serve written notice pursuant to the Real Estate Act. If tenant does not comply with the requirements of said notice in 18 days, the premises shall be deemed abandoned. 21. Validity severability. If any provision of this agreement is held to be invalid, such invalidity shall not affect the validity or enforceability of any other provision of this agreement. 22. Attorney fees. In the event action is brought by any party to enforce any terms of this agreement or to recover possession of the premises, the prevailing party shall recover from the other party reasonable attorney fees. It is acknowledged between the parties that jury trials significantly increase the cost of any litigation between the parties. It is also acknowledged that jury trials require a longer length of time to adjudicate the controversy. On this basis, all parties waive their rights to have any matter settled by jury trial. 23. Notices. All notices to the tenant shall be deemed served upon mailing by registered mail addressed to the tenant at the subject premises or upon personal delivery to the premises, whether or not tenant is actually present at the time of said delivery according to the Residential Tenancy Act. All notices to the landlord shall be served by registered mail or to the landlord's agent. 24. Personal property of tenant. Once tenant vacates the premises, all personal property left in the unit shall be stored by the landlord for 18 days. If within that time period tenant does not claim said property, landlord may dispose of said items in any manner landlord chooses. 25. Additional rent? None. 26. Application. All statements in tenant's application must be true, or this will constitute a material breach of this lease. And then we have 27. Indemnity by tenant. So, indemnity by tenant. The tenant shall save landlord harmless and indemnify landlord from all injury, loss, claims, and damages to any person or property while on leased property, unless caused by willful acts or omissions or gross negligence of landlord, its employees, licensees, or contractors. 28. Additional terms. 29. Entire agreement. The foregoing agreement, including any attachments incorporated by reference, constitute the entire agreement between the parties and supersedes any oral or written representations or agreements that may have been made by either party. Further, tenant represents that tenant has relied solely on tenant's judgment in entering into this agreement. Tenant acknowledges having been advised to consult with independent legal counsel before entering into this agreement and has decided to waive such representation and advice. Tenant acknowledges that tenant has read and understood this agreement and has been furnished a duplicate original. So you've got the lines here for the landlord agent to sign, the witness, the date, the tenant, the witness, the date, the tenant, the witness, date. And then it says here, no representation is made as to the legal validity or adequacy of this agreement. If you desire, consult with an attorney before entering this agreement. Important legal document. This tenancy agreement is an important legal document. Keep it in a safe place. Condition report. The landlord and tenant are required to inspect the unit together at the beginning and end of the tenancy and complete a written condition report. A report may describe any damage, how clean each room is, and the general condition of the unit, including the floors, carpets, appliances, and paint on the walls. The report must be signed and dated by both the landlord and the tenant who made the inspection, and each should keep a copy. Change of landlord. A new landlord has the same rights and duties as the previous one and must follow all the terms of this agreement unless the tenant and new landlord agree to other terms. Resolution of disputes. All problems or disagreements arise, if problems or disagreements arise, the landlord and tenant should try to talk to each other to find a solution. If they still cannot agree, either may contact their legal advisor for clarification of their rights and responsibilities or an intervention. If no agreement is reached, a landlord or a tenant may apply for a dispute resolution to get a decision. Many, but not all, kinds of disagreements can be decided by dispute resolution. And that is the end of this commercial lease agreement. Thanks for watching.